Hi, good morning everyone. Thank you for joining us today. This is a webinar designed for employers who want to safeguard their business and optimize their workforce in the ever-changing legal and business landscape. The risks associated with non-compliance, poorly managed contracts, and high employee turnover are growing. So today we'd like to just cover and give you some insight and tools to navigate these employment law and compliance changes and requirements and HR challenges we see a lot of our clients are facing and how we can help you retain your employees. So together we'll explore some of the do's and don'ts of HR compliance so that you can identify and resolve concerns before they spiral out of control, helping you avoid costly disputes, settlements, and negative media attention. If you have any questions throughout the webinar, please feel free just to write them in our Q&A section. But these can be asked throughout the webinar. You don't have to wait until the end. As an introduction, we are Dragon Argent. We are based in London, London Bridge specifically, and we are a legal accountancy and advisory firm. Here is an outline of what we will be covering today. My name is Cacy Neilson. I'm the head of the employment and immigration team here at Dragon Argent, and I'm joined with my colleague Didi, who is an employment solicitor. We also have two trainees in our department called Sarah and Elogina. They will not be joining our presentation today, but they are always on hand should you have any questions. So let's begin, and I'll pass over to Didi to start.
Thank you. So we are going to get into a quick introduction into employment law. Employment law sets out the clear rights and responsibilities for both employers and employees, and it forms the basis of the employee and the employee relationship. Basically, it's the minimum that an employer or an employee, can expect from their employer. So, of course, you have employers and companies that go beyond what is required from them from a legal perspective in order to foster good employee relations and encourage involvement, engagement, and loyalty. However, what it is important for you to know as employers is that it's imperative for you to understand what your legal obligations actually are and the legal risks that can attract from your actions and your inactions. So we'll now go through some of the key provisions of the employment legislation that employees need to be aware of when managing employees and to reduce the chance of a successful legal claim, because they do happen. This will be a whistle-stop tour of the legislation, as this webinar is only an hour long, and so it is impossible for us to go through it in any great detail, but we hope to just give you some of the main highlights. So here is an introductory list of some of the main rights that workers and employees have. This list is by no means exhaustive. So both employees and workers are legally entitled to what is known as a written Section 1 statement of particulars of employment. However, an employee will have an employment contract with their employer, but that contract still needs to incorporate the written Section 1 terms of employment. So we'll explore contracts for employees and workers later on in the webinar, but for now, as you can see, there are rights here that are listed that apply to both workers and employees, and there are some that just apply to employees. So workers are not entitled to a minimum notice period. They're not entitled to protection from unfair dismissal. They don't have a right to request flexible working hours, and they don't have a right to statutory redundancy pay. So let's explore some of these rights and the corresponding legislation in a little bit more detail. So we'll look at paid annual leave, sick pay and national minimum wage. So quite hot topics, I'm sure you've heard of them. So paid annual leave is a legal right that an employer must provide. So almost all people that you employ as either employees and workers are legally entitled to 5.6 weeks paid holiday a year. And if you want to look at it in days, for somebody who works a 5-day work week, that makes up 28 days paid annual leave, and that can actually include bank holidays, but we won't get into that right now. And holiday pay needs to be calculated correctly, and it's based on the employee's working pattern. The principle is that paid holiday an employee or a worker is on paid holiday, they should be receiving the same amount of money that they would receive if they were at work. Employees must also be paid sick pay if they're entitled to it. So they can be paid statutory sick pay up to 28 weeks, and at the moment it's currently £116.75 a week, and that is the minimum what an employer must pay. You cannot pay any less than that. You can pay more if you want. We see a lot of companies pay more, of course, but the whole point is that if you pay any less, you will be in breach of the legislation. By law, an employer must also pay national minimum wage. Again, a hot topic. It changes basically every April, and you can pay no less than that. It's something to be very careful of. Employers sometimes find that they're mistakenly actually breaching national minimum wage regulations, because either they're charging people, to pay for their own uniforms, not knowing that that actually brings national minimum wage down. Next thing, you're faced with a claim, and rightly so. So that's something to be aware of. An employer who repeatedly fails to pay national minimum wage actually does risk prosecution, so it is one to be wary of. Moving on swiftly to protection from discrimination. Again, a hot topic, something that, again, I'm sure you've all heard of. But the point here is that the Equality Act 2010 protects people from discrimination in the workplace. So what does it mean for you? It means that you've got a duty to make reasonable adjustments for disabled employees and workers. We do have an article on reasonable adjustments, so feel free to find that on our website. And you cannot discriminate against your workers and employees based on the 9 protected characteristics. These are age, disability, gender reassignment, marriage or civil partnership, pregnancy or maternity, race, religion or belief, sex and sexual orientation. As an employer, you can actually be in breach of this legislation before you've even employed somebody. So you've got to be careful when dealing with candidates, when you're in a interview situation, asking a candidate, for example, about their family plans. That might be an innocent question, but actually you could be breaching the Equality Act 2010. So care should be taken by you as employers to ensure that you follow the law on discrimination when you're advertising for new roles and interviewing. And then we've got protection against unfair dismissal that applies to employees. Again, this is a big topic, and on its own we can have a webinar that would last for more than 1 hour. As employment solicitors, it's our bread and butter, it's what we deal with day in, day out. And the whole point here is that employees who have 2 years service have the right to not be unfairly dismissed. This means for you as an employer that you need to have a fair reason for dismissal. The reason must be enough to justify dismissing the employee, and as an employee must follow a fair procedure. So fair reasons for dismissal can be the employee's conduct, maybe their capability and their qualifications, they can't actually do the job. Redundancy, again we're going to explore a little bit of redundancy later on down the line. The fact that contravention of the duty, it's maybe a contravention of law to actually keep employing that employee or some other substantial reason. There are some exceptions to this, and sometimes you don't actually need to have 2 years service to be protected. So if you're dismissed for being part of a trade union, for example, again, it's a big topic, but watch this space. I'm not sure if a lot of you have seen what's been happening in the news recently with the new Labour government, but their Employment Rights Bill, which was published last year, is proposing to make unfair dismissal a right from day one. So employers will not enjoy that benefit of being able to wait for 2 years. This is going to be a massive change. And obviously, as employment solicitors, we will be keeping you updated. I think I noticed we had a question. Can I quickly have a look at that? Paid sick leave is for £116.75. Is it the same amount for working students? This is a very good question, a question that I've not had before. It will depend on the status of the student, whether they actually are an employee. But leave this with me to check, and I will actually come back to you, because I've never actually thought about that before, whether students, I would have thought so if they're an employee and a worker.
If they're a full-time employee working like anyone else, and that is the key thing that we do also we're coming across a bit in a few more slides, is if an employee is a full-time worker, part-time worker, turn-time worker, they should all be treated the same. You shouldn't discriminate against, or you shouldn't discriminate against them or give different entitlements for different workers. So based on that basis, I would say yes, they should also be entitled to the same pay, but we can get back to you on that.
Thank you. So I think that's me done for now, and I'll be handing you over to Cacy now to go through HR compliance essentials.
So HR compliance essentials. HR and employment compliance really are an essential part of business success, and navigating the ever-evolving world of HR compliance is a critical responsibility for every business, regardless of your size or the industry that you're in. It's really important that your business is aware of your duties as an employer and what employees' rights are. So we believe that HR encompasses everything. It's quite a broad topic. It encompasses the laws, the regulations and policies, and how to govern your workplace culture, practices. And we think staying compliant with the law is not only a protection for your business, but it's also a fair treatment of your employees. If you do neglect to do this, it can lead to disastrous consequences, costly legal penalties, and that is something that we see time and time again. In order for a business to be HR compliant, there are a number of things that need to be in place, and we'll run through some of these today, but by no means is it our full recommendation. There's a lot to be considered, and it is based on a business-to-business case and industry-specific as well, but these are the common ones that we come across with our clients. So an employee needs to know what their employment law duties and obligations are, and what the minimum rights for employees are. So we have touched on some of these in the employment law introduction by Didi today. Compliant employment agreements and workplace policies should be in place. So these should also be updated from time to time, and we do recommend that these are reviewed at least once a year, but 1 to 2 years is around about a good basis to start from. The legally required policies. So there are some policies that by law should be in place for every business, no matter the size. So this includes your disciplinary and capability policy, a grievance procedure, a privacy policy, a health and safety policy. And the health and safety policy is only required where you have 5 or more employees, but the other policies mentioned are required for all businesses. Then there are policies that we recommend commercially that every business should have in place. So as I said, this is not a legal requirement, but this is our commercial recommendation, mainly because this is where we see a lot of disputes arise, and it's a common area that our clients come and ask us questions on. So this is to do with your holiday, sickness, absence, anti-harassment and bullying, equality and diversity, remote working policy. And the remote working policy can be a hybrid working policy if that is something that you have in place as well. You might, as I've just reeled off some of those policies, you might be thinking, actually, these are the common issues that we have in our business. So feel free, if you've got any questions, to write to us now. If you'd like to get in touch following the webinar to find out more about how we can help you put these policies in place, or review any that you do have, please feel free to send us an email. We do have some packages and pricing options that we can offer. Another key compliant HR essential that we do see being a big issue between our clients coming time and time again is the status of independent contractors or employees. So you should have correct agreements in place, and independent contractors should be treated in a manner that demonstrates that they are truly a contractor, as opposed to an employee masked as a contractor, as this can cause big financial problems for you later down the line. Everything may be happy now, an employee slash a contractor may be happy on the terms as is, but when things go wrong, all it takes is one phone call to HMRC and for them to come in and do an audit on you. You should be aware of how to manage performance and conduct issues. So again, that is the compliance essential. We do provide a separate training on how to actually manage underperforming employees or long-term sickness absences and grievances. So again, get in touch if that is something that you'd like to find more information on. And another compliance key is to provide a healthy and safe working environment, and to process employee and worker data in accordance with GDPR and UK data protection laws. So next slide is our best practice for ongoing compliance. Everyone knows about it. It's a huge topic at the moment with AI and how it's changing business landscapes, globalization, regulatory reforms, and ever-evolving client expectations. We find these are the key things that are primary drivers for changing the legal industry. So to make your business ensure that you're adapting to these changes and keeping on track with your legal obligations, we do suggest the following things to help you have your HR team be compliant. You should carry out an HR audit 1 to 2 years to identify and fix any compliance gaps that you see. You should actively seek legal updates, so you can sign up to our newsletter. We do send updates via our newsletter or on our website. You should establish clear policies and procedures that align with regulatory requirements, and you should train your staff to actually follow your policies. Again, we see this so often that policies are put in place, no one ever reads them, and they're never followed. It is a big thing that if you've gone to the effort of actually putting a policy in place, you should follow it. And when you are in doubt, get in touch with the lawyer, ask us any questions that you have. That can often, a quick 10-minute phone call to a lawyer can often steer you in the right direction and save legal fees later down the line.
Save you a lot of money.
So some common pitfalls and best practices that we see. Number 1, employment discrimination. So employers must ensure that all employment decisions are made with regard to protected characteristics, which Didi has highlighted before, but I'll just reel them off again. They are race, colour, religion, sex, national origin, age, disability, or genetic information. HR must be vigilant to avoid discriminatory practices in hiring, in promotions, in giving employee compensation and in terminations. So do always have that in the back of your mind. Is there any potential discriminatory element to this? Number 2 is the improper classification of employees. As an employer, you should accurately determine whether an individual meets the criteria for an employee or if they are truly an independent contractor. This is based not just on contracts, but also based on what's actually happening in the true working relationship. So this is factors such as control, integration of the individual in the workplace, how they are paid, how much they are paid, how often they are paid, and what is actually taking place in reality. Of course, your contract between yourself and your contractor can set out the contractual terms, but in reality, judges will always see what is truly going on in this relationship. Number 3 is inconsistent or improper disciplinary actions. So HR professionals must ensure that disciplinary actions are taken consistently, proportionally, and as per your actual policies that you have in place. Inconsistencies with your policies, so i.e. where a manager just decides something off the cuff, this can really lead to poor employee morale and claims of unfair treatment. The fourth thing that we see the fourth common pitfall that we see is breach of confidentiality and inadequate record keeping. So where you mishandle or disclose sensitive confidential information can result in violations of privacy laws that will not only expose your business to financial repercussions, but it also erodes your trust with your employees. As a business, you should fully record details of every employee. So on the next slide, we'll show you the exact items of personnel information that you should be keeping and personal information that you must by law keep. So for example, records of employee contracts, performance evaluations, disciplinary actions, and employee complaints. Failing to actually accurately keep all of these records in these areas can make it challenging for you as a business to defend any legal claim. If you have all of these documents in place, you can demonstrate compliance with the laws, and you can also demonstrate any decisions that you have made. So here is a quick slide of employee records that you must keep and you should keep. So for example, on the must keep side is obviously an employment contract. That is a requirement because it's meant to be in place. Right to work checks, we do see a lot of businesses fail on this one. It is a legal obligation for you as a business to check every employee's passport, not just your foreign workers. It means everyone. You should also note, if you do have migrant workers, any visa that they are on, and note down when these expire. Each time you make a check for an employee's right to work, these should be kept on record, all of them. Don't remove the previous ones that you've done. Otherwise, you can't prove that you've done them previously. A third thing, to absolutely keep on record is your pay rates and payroll information. This is a legal requirement by HMRC. You should also keep sickness absences, accidents, injuries, and dangerous occurrences. This is to meet health and safety requirements. And the final thing on must keep is your employee personnel details, such as employee's full name, residential address, contact numbers, and email qualifications, and their CV, if you still have that, their emergency contact information, and any work-related disabilities. Now, on the right-hand side, you will see a list of information that we suggest you should keep. This is our commercial recommendations, and this stems from issues that our clients have had in the past, and had they had these things in place, it would have helped their case a lot better. So for example, job descriptions. This will clearly evidence what an employee's job is, what their expectation of the role is, and when things have changed. You can accurately show, this is what we as a business expected you to be doing, this is where you are, and it shows the difference if you are wanting to go through an underperformance review. You should keep the documents of any recruitment process that you have undergone, such as the job advert, the offer letter, interview notes, references, and the onboarding process that you followed when hiring all staff. You should keep compensation arrangements, so this includes bonus agreements and salary increases. You should keep performance and appraisal records, so any meeting note, any preparation for performance review, any feedback that you receive from other staff. You should keep disciplinary action and outcomes, grievances and outcomes, and absences, such as records of lateness, sickness, and annual leave, and unauthorized absences. And finally, training and development. So this is a big one that's come in recently. In October, the laws did change. There is a new requirement on sexual harassment that the employer now has a duty to prevent harassment in the workplace. Showing that you have provided your employees with training and staff development acts as a defense if a situation or a dispute were to arise. So it's just making sure that you have evidence to prove you've really done all your due diligence and your HR. Moving on to the next topic, which is employment contracts.
So yes, we'll move on to employment contracts and the key elements of one, the different types of contracts that you're going to come across as an employer, and mitigating potential legal issues. So when it comes to employment contracts, all employees really should have an employment contract. An employment contract can be agreed verbally, so it can be agreed through conversations. It can be agreed in writing, so when you have a job offer letter, through emails, and part of an employment contract can also be agreed through your conduct. So this is when someone's actions show that there's an agreement. So even though it's not written down or spoken about, their actions demonstrate something else. So you see it often when an employee, for example, is regularly paid a bonus. Though there's been nothing in writing to say that Joe Bloggs is entitled to a bonus every quarter, because he gets one every quarter, it basically becomes a contract. So as I touched on before, both employees and workers are legally entitled to a written Section 1 statement of certain particulars of employment. And this must be provided before the worker begins work. That's a very key element. It can't get them out, it's not supposed to be afterwards, before they begin work. And if you've got an employee and they have an employment contract, well, that employment contract needs to incorporate those Section 1 written statement terms. If you fail as an employee to provide a Section 1 statement or a contract that fully incorporates it, a claim can be made against you by an employee or a worker in the tribunal. So what does it need to include? So the slide here has a list here of everything that it needs to include. This is the minimum that it must include. So we have the employer's name, their job title, job description and start date, their details of pay and how often they're paid, hours of work including any variations, holiday entitlements including bank holidays, the work location, the duration of the job, particularly in fixed terms contracts, probationary period or whether one even exists or not, other benefits such as childcare and obligatory training specifying whether an employee is paid for that. So that is some of them. I don't know if that was actually all of them, but if you need to check, it's all online, Section 1 of the Employment Director.
We also have an article on our website which lists all of the key elements that need to go in an employment contract.
Thank you. And so then moving on to different types of contracts. Now this is a crucial element for an employer to provide the correct contract. Sorry, I'm distracted. Oh, what I'll do is actually I'll have a look at the question that we've just got in. What happened if some benefits were stated in the contract but are not in place? Should we worry? What happened if some benefits were stated in the contract but are not in place? Yes, you should worry, because if it's in the contract and it's actually a contractual requirement, you could be in breach of that contract if it's not actually happening in practice. A lot of it will depend on the wording of the contract as well. So it's whether you've said that it is discretionary or is it actually a contractual entitlement. So be careful there and feel free to get in touch with us after the webinar. Send us an email and we can take a cursory review of that. So moving on to different types of contracts. For you as an employer, it is crucial to have the correct contract for the correct type of worker to ensure that everything reflects the nature of the relationship and what is actually happening in practice. The contract should be adapted to the employee's specific circumstances, so not one size fits all. If it's in the contract, it needs to be, as we've seen, it actually needs to be taking place, it needs to be happening. The correct contract also helps to define the employer-employee relationship and avoid disputes over the interpretation of the contract. So clear drafting is vital to minimise the chance of a dispute about the true meaning of a term and to also avoid the courts interpreting ambiguous terms to the detriment of you as an employer, and they do have the power to do that. It's in your interest to have the correct contract. Provided and so that everyone knows where they stand. For example, if you had a volunteer in place, you wouldn't want through your actions to create an employee or worker rights with that volunteer. So having the correct agreement in place can mitigate that risk. So what are some common pitfalls when it comes to drafting employment contracts? Again, like we've just mentioned, terms that are not clearly defined can lead to misunderstandings between you and your employee, can result in disputes and legal challenges. For example, not making it clear whether bank holidays are included or not in a holiday entitlement. Another common pitfall is failing to regularly review and update your employment contracts. Employment laws and regulations are continually evolving, as we've seen. Massive shifts are coming, and we still receive contracts to this day that don't even incorporate the changes of April 2020. That is
coming up to 5 years now.
So it's coming up to 5 years. Automatic breach that could lead to a claim. Another pitfall that we see is some employment contracts don't contain all the key elements that are required, as we discussed previously. We've got some, again, listed here, and how to avoid them. But if you're ever in doubt, get in touch with a solicitor, get it reviewed. It is worth it because it saves the money and saves all the time. If you would like to send us a contract, obviously feel free to do that. We're currently offering a complimentary red flag review, so we can let you know if your contracts are actually compliant or not. So yeah, please do get in touch. So moving on to strategies for employee retention, a big one. And Casey's going to take it away with that. Thank you.
Thank you, Didi. So why is employee retention important? Again, this is a question we get a lot from our clients. They think of ways. So at DA, we specialise not only in giving legal and tax advice, but we also like to give a commercial approach. So because we deal with a lot of similar clients in similar industries, our clients want to know what are others doing, and these are some of the commercial elements that we advise on. So employee retention is really vital for the success and sustainability of your business. By prioritising your employee retention, your business can actually create a stable and engaged and high-performing workforce that then drives a long-term success for your business. Some key benefits of employee retention that we find are, number one, financial benefits. So higher levels of productivity, efficiency, and profitability. Increased revenue, so employee retention can lead to a better customer service, which can then of course increase the company's revenue, and reduced hiring costs. We have seen that finding new team members can really be costly, and on average replacing an employee can cost the business 1/2 to 2 times their salary. So companies can really save a lot of money by actually investing in their current workforce rather than always looking for new candidates. The second biggest part that we see helps employee retention is a workforce culture. So higher turnover rates can lead to low employee morale. So this prevents a challenge as employees are no longer excited about work, and each employee is integral to a company culture. So in turn, all employees benefit, which then leads to attracting top talent. Your professional reputation. So when companies are able to retain employees, this is good for public relations in turn, and increases profits, positive press, and competitive hiring edge. Stability during change. So again, if you have a strong workforce during any period of transition, such as leadership changes or market shifts, retained employees can provide a stable work environment and loyalty to the organisation to allow your company to actually get through these challenging parts without having to also consider employees coming and going. And finally, of course, it attracts top talent. So we've got a question in, which is, what's your view on mentoring programs attributing to retention? It's like you've read our slides because we actually come up to this later down the line. It is one of our top tips. I think it might even be on the next slide. Yep, it is on the next slide, so I'll get to it now actually. This slide highlights some main factors that contribute to high staff turnover, and as part of our effective strategies to improve retention, we've then listed some examples there. So in a poor leadership or management scenario, we do find often that some of our clients' issues are actually to do with management and not to do with the employees. So ineffective or unsupportive managers can actually demoralize your employees, which can lead to dissatisfaction. A big part of that is poor communication and micromanagement and lack of recognition of your employees, and often where to push. So these are often things that push employees to leave. So how would you avoid these situations? So for example, you should train your managers to lead with effective communication and employee development. And you should provide regular feedback, both good and bad. This is a very key element because it not only benefits employee development and retention, but it also provides evidential record where you wish to terminate an employee in the future for underperforming, because you are required, as we touched on previously, you can only dismiss employees with more than 2 years service for a fair reason. So if you have evidence of an underperforming employee and you've shown how you've tried to help them improve, that is your clear evidence and a fair reason. Another main factor which contributes towards high staff turnover is lack of career progression and opportunities. One of our effective strategies to improve this is to obviously, as the question was. So offer mentoring, mentoring or coaching sessions, and to encourage and help an individual develop their career and highlight maybe where they want to see themselves in 3 to 5 years and how they can get there with working with your company.
It just shows that investment, doesn't it?
Exactly. Another factor is little to no work-life balance. So we see this a lot at the moment. Excessive workloads, long hours, or inflexible working schedules can lead to employee burnout, prompting employees to take frequent or long-term sickness absences, or eventually leaving their employment. So as a business, you don't have to offer them the world, but you can consider offering flexible working arrangements such as remote working, compressed work weeks, or flexible hours. If you do offer any of these, we strongly suggest the terms of these are set out in a policy, which can change, which allow you to then change these flexibilities from time to time. Do get in touch with us. We do encourage employees, you should encourage employees to take their annual leave and avoid burnout by monitoring workloads. I won't go into all of the other ones in super detail either, but basically just to run through them quickly, lack of recognition and appreciation. So this is a big one that we see with junior staff members. And a good way to try and avoid that is promoting a healthy work-life balance or recognizing and rewarding an employee's contribution. And the big one is inadequate compensation and benefits packages. So we do see a key element why employees tend to leave is their low salaries, minimal benefits, or lack of incentives can drive employees to leave. This is a difficult one that we do find our clients struggle with, because where you are trying to keep employees and offer them the world, but you do realize you've got competitors who can actually offer the world, but you might be more tightly money strapped. It's looking at other ways of doing that. You don't always have to offer match salary. You can consider other benefits. So for example, consider providing performance-based bonuses. So that's purely on if an employee performs to a certain level, they will then be rewarded. Private healthcare is obviously another one that everyone wants to have, but I don't think employees recognise the cost that this is to businesses. So another alternative may be to allowing other flexible working arrangements or additional leave entitlements. So for example, here at Dragon Argent, we offer an additional day of annual leave for long-term service for employees. So for example, at 2 years and 5 years, they get an additional day's leave. We also offer something that's called a bank holiday swap. So where we have staff who celebrate different cultures, they may not celebrate Christmas and Easter, so we allow those staff members to work those days and instead use those bank holidays for their religious festivities. Again, promoting a more inclusive culture and more happy workforce. We know a lot of employees really appreciate that element. So it's thinking of other ways that doesn't cost us any more to the business. You're essentially just using something that's already in place in a different way. Supporting employees through redundancy. So this might seem as a random input in our webinar today, but it is a hot topic that a lot of individuals who got in touch with us prior to this webinar are asking questions on. So we thought we'd add in a topic on this.
Thank you. So navigating redundancies, it's one of the most challenging responsibilities that you as an employer have. And it's very important that you get it right. Redundancies can sometimes be unavoidable. They can have lasting impacts on employee morale, company culture and reputation. But most of the time, if you've had to use redundancies, it means that there probably is a good reason for it. But it doesn't mean that you can't support your employees in a nice, empathetic, clear way. In the end of the day, we're all human beings. And it's important that we support each other from a nice moral standpoint, and then obviously legally you need to make sure that you're not getting anything wrong and being faced with a claim. So by understanding how to provide empathetic, clear and actionable support, you can ensure a smoother transition for your affected employees while maintaining trust and morale against your remaining team members. So how can you do that? So, well, for employees, redundancy means the loss of a job, that they depend on for income, along with leaving behind colleagues and a role that they may find fulfilling. And for you as employers, it can mean losing a dedicated, valuable staff member, some of whom may be difficult to part with, and you would ideally like to stay in the situation. So, supporting employees through redundancy, you want to be clear for the reasons for the redundancy. Explain the redundancy process in terms that can be understood. Conduct a thorough consultation process. Offer support through the process and be mindful of an employee's personal circumstances, and be clear on their entitlements upon termination. So if I go through those in a little bit more detail, again, you don't want to lose your staff voluntarily, which is why you're having to result to redundancies. So it's likely that other options and cost-saving measures have been explored to avoid undergoing the process. So it is helpful to explain the steps that have been taken and why. And then obviously you want to conduct a thorough consultation process to reduce the risk of receiving an employment tribunal claim. So it's essential that to conduct those through consultations with employees who may be affected by the redundancy process. And these consultations shouldn't be treated as a mere formality and legal requirement. They need to be considered, and they are best practice. The meetings need to be genuine. Employees can tell when things aren't genuine. And with employees, it's more than about the fact that their job is going. You want to make sure that you're genuinely considering if there are any alternatives to redundancy. Sorry, I'm just smiling at this question because it is a good question. Why would an employer make a dedicated employee redundant? Well, a lot of employers don't actually want to do that, but the whole point of redundancy, it could be because the business is actually struggling financially, it's going in a different direction, maybe you're wanting to make a certain department more efficient. So those can be the reasons basically for making someone who's a dedicated employee redundant. But of course, if there are alternatives to employment, if there are a suitable role that they could be put in, that is something that can be explored. But the whole point of redundancy, why the government have that in place, is so that businesses can react to the financial situations, for example, and changes
where there's no other
COVID.
alternative. Yeah. That is why, as part of the redundancy process, you are supposed to consider if there's any suitable alternative employment for that individual. So where you have an individual that is a dedicated employee, you probably would put more emphasis on trying to find another role that they can move into rather than losing them.
And so then just on that, we'll go through it. I'm just conscious of the time.
I think a key element for you to cover is to be clear in entitlement on termination. We see this time and time again where a company terminates an individual but doesn't explain to them.
Yeah.
They run through the redundancy process well, but then don't explain to them what happens afterwards. So that is sometimes a key thing as well.
Yeah, a key thing, and it's down to the documents that you provide. So being clear and transparent. Termination letter with termination arrangements, it goes a long way. And I'll leave it at that.
Okay. So our next slide is just the key takeaways from the webinar today, and then we'll have time for additional questions that come in. So recap, today we focus on employee satisfaction, which is a key for financial growth for an enjoyable culture environment for a business to succeed. Part of the main topics that we did cover today are we covered that you should ensure there is someone in the business who understands employee rights and employee duties. So I know in our webinar today we did refer to HR team. We understand not all businesses are large enough to have that. There just needs to be someone who has an understanding. Sometimes we see this as a director even, just that they are actually aware of what an employee's obligations are and what employees' rights are when you are managing, hiring or firing staff. Another key element that we cover today is really you need to ensure your employment contracts have the minimum information required by law. That is your absolute minimum. We do offer a commercial review of contracts as well. So this is where we can advise, whilst your contract might be compliant with the law, there could be other commercial elements and protections that you can put in to help actually protect your business interests. You should implement and update and or follow your policies. So again, we touched on how important it is, if you have policies in place, to actually follow them. There should never be an excuse to discriminate. There should never be an excuse to discriminate, even if it is accidental. And you should keep all personnel records up to date. And bear in mind the importance of work culture and employee satisfaction. Some of the practical steps that we cover today some of the practical steps that we can help you cover what we did today is have us review your contract to ensure that they are compliant with the current laws. So as Didi touched on, we are currently offering a complimentary red flag review. So if you would like to send us your employment contract, we will get back to you with some of the things that we've spotted, i.e. are not compliant with the law, or where you can improve them. We will then suggest how much it would be for us to do that, to carry that work out for you. You should ensure that your policies are up to date and take into consideration the upcoming changes. So do sign up to our newsletter, or just keep in touch with us or on our website. We will be updating the changes as and when they come in. And carry out, a big suggestion that we do have for all businesses is to carry out an anonymous questionnaire with their staff. This is a great way to see how happy staff members actually are, and it can be a good way to highlight, for example, some of the benefits they would like to see. As we mentioned, not all of them are expensive benefits. It could just be have a water cooler or have some fruit in the office. Little things like that will add to employee satisfaction. So we do strongly recommend carrying out a staff survey to see how your business is performing internally and any recommendations that they may have. Finally, don't be afraid to use qualified legal professionals, whether they are us or someone else. Sometimes things do get too complex or complicated and could have been avoided had you had a quick 10-minute chat with a lawyer just to direct you in the right direction. So do get in touch with a lawyer if you have any questions on that. Speaking of which, we do actually offer an HR and employment advice retainer. The purpose of this retainer is to help you, one, financially know. We do understand the financial burden of having legal advice. If it's spread across a year through monthly payments, we find that our clients see that that is a lot more helpful. And how the purpose of the retainer is for us to help you remove your HR administration burden so that you can actually focus on what is important, which is your business. So we offer two packages. The first is a basic HR monthly retainer. The difference between the packages is literally the amount of hours that you get per month. So in the basic one, you get up to 2 hours of phone calls per month, which with our employment specialists for employment immigration queries, and for the premium, you get up to 4 hours. The other element as part of the retainer is preparing and sending offer letters, preparing and sending employment contracts, and carrying out right-to-work checks for your new employees. That leads us nicely onto whether you have any questions or any additional questions or comments for us. We'll wait for a few more to come in. Feel free to write them or to even sorry.
I don't think we have any questions in, which is absolutely fine. And thank you very much for the questions that did come in through the webinar. Feel free to contact Cacy or me if you've got any questions afterwards. Have you got any final words?
Yeah, the webinar will be available on our YouTube channel and on our website. So we won't be sending out the slides. You will get an email following the webinar with the link to all of that. And feel free to respond to that email if you've got further questions or would like to get in touch with us. We do also offer a 30-minute discovery, a complimentary 30-minute discovery call. So that's not only just for our department, that is for the whole firm. So we do offer corporate and commercial advice, IP, litigation, art law. That's our legal side of things. And on the accountancy side, we do have a whole accountancy practice. So again, if you've got questions on that area of your business, feel free to get in touch with one of our accountants. for a complimentary 30-minute call as well. Thank you for joining our employment and immigration webinar today.
And if you have any further questions, feel free to click the link below, and we look forward to hearing from you.